Good morning. Please be seated. We are here for oral argument in cause number CV16-0031, Meyer et al. Versus State of Arizona. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. We have read the briefs provided. We have conferenced this case, and we are familiar with your arguments. Given that, counsel, you may proceed.
Good morning. May it please the court. I'm Rusty Crandall here on behalf of the state of Arizona. Plaintiffs do not dispute that Prop 202 contains a number of benefits. The question in this case is whether benefits should be interpreted to mean the benefits that Prop 202 provides, or whether it should be interpreted to mean fringe benefits. The court should reject plaintiff's interpretation for 5 reasons. 1, it ignores context. 2, it creates ambiguity. 3, it results in an implied repeal of a state law. 4, it conflicts with federal law. And 5, it significantly changes Arizona law without alerting voters. Turning first to context. Context supports the state's interpretation.
Before we get to context, ambiguity, all of these things, let's talk about plain meaning of the statute, which is what we're charged with looking at first. So if we start with plain meaning, why would benefits not mean what benefits means in the general context of non-monetary compensation? That's kind of what I'm having a difficult time getting over. So can we start there and then we'll go on with your 5 arguments?
Sure. And if this case was just what does wages and benefits when those words are used together, we wouldn't be standing here. Traditionally, the words wages and benefits when used together means fringe benefits, but it doesn't in this context. The context here is minimum wages and benefits. And there's not...
The context also, though, that cities and counties can mandate higher wages and benefits if they want. They just can't go under a floor.
The context is a provision that is off. It's within an enforcement context. So it is a provision that is giving certain entities. The commission is given certain power, the legislature is given certain power, and cities and municipalities are given certain power. And it's authorizing them to regulate certain activities. And that's the question here: is what is it that they are authorized to authorize? And we believe within this enforcement context and the limiting words throughout every single paragraph within the enforcement context, within this enforcement provision, says this article, this article, this article, this article. So we believe the context is this article, and you should look to the article for that.
So let's go back to HB 20 before HB 2579. There would be nothing that would indicate counties or cities didn't believe they could pass requirements that benefits, as we traditionally understand them to be, could be raised. Mandated.
There was a law that was settled away, but yeah, generally before that, cities could regulate benefits unless it conflicted with the state law.
And cities were always constrained by complying with federal regulations in regards to benefits, correct?
Correct, of course.
And still are?
Correct.
Okay.
So HB 2579 only attempts to take that authority away from the cities.
Correct.
And that would be contrary to what the initiatives said, where they specifically recognized that cities have that ability to do.
Well, I mean, that's the question in this case, is what was this provision recognizing that cities could do? And this is not just simply a recognition of cities, what they can and cannot do. The context here, I mean, what this is...
Not what they can do, but what they have done.
Sure.
I mean, after that, the initiative was passed, prior to HB 2579 coming into being, cities did it.
Yes. They had, I don't know, again, the federal law prohibits a lot of what you can actually do here. But really what is the heart of this is Prop 202 is a voter-protected law. So it significantly changes the state can generally, except, if it's, I forget the rule, but generally the state can limit and generally whittle away at whatever power the cities have it. Generally, they can do what the state authorizes them to do. So what is unique about this context is that Prop 202 is a voter-protected law. So that prevents the state from regulating.
Do you agree that it still prevents that the legislature could not have come in and said, counties, you cannot permit a higher minimum wage. You cannot impose a higher minimum wage on people. Just wage. Forget benefits.
Absolutely.
It's okay for the city of Flagstaff to say the minimum wage in Flagstaff is now $40 an hour.
Yeah, because of Prop 202,
and you agree that there's nothing, the state can't come in and pass unless it's with a 3/4 vote or whatever, it complies. But so why is, I'm having a disconnect. If Flagstaff can come in and say current minimum wage is $20, we could either require $20 plus $20 in insurance benefits, or we can simply require that you pay $40 in wages. How is that any different? That it's okay for them to come in and say the minimum wage in Flagstaff is now $40, but it's not okay for them to come in and say the minimum wage in Flagstaff is now $20 and you have to pay benefits in the amount of $20 per hour?
That is the state's position, and the state has, and Arizona law treats wages and benefits differently. So,
isn't it compensation? Does anyone taking a job treat it differently? Isn't it? This is the amount of compensation I'm receiving, or the wages and benefits?
Wages and benefits. I mean, there's ways to get around ERISA. There's ways to get around, state regulations, and what Your Honor has proposed would perhaps be a way to get around the way that the state is interpreted by, just front loading the wages.
Challenge that if Flagstaff just came in and said we're going to raise the minimum wage to $40 over instead of $20 or whatever the highest amount ends up being.
Correct. And one thing about that is it requires the electorate to actually and understand the cost of it. If you say that we are having a $40 minimum wage, at least you understand the cost that is being imposed on employers. When you put all of these, non-wage compensation into benefits, it's hard to internalize the costs.
But in fact, isn't the state saying that we would like to be the ones to dictate the non-wage compensation for everybody in the state of Arizona?
What the state has said is it is a matter of statewide importance and that cities are not free
But
to.
why is that more important than the minimum wage? Just the wage aspect without the benefits. Why are benefits important but not the wage?
I apologize if I've given the impression that benefits are not important. Benefits aren't important.
But if it's of statewide importance, it's a disconnect for me when everybody who takes a job views this is my compensation package. So I understand why the state would want to have consistency throughout the state. Employers who are employing people in different cities don't want different requirements. I understand there's a basis for it, but if you're acknowledging that there's nothing that keeps cities from increasing the minimum wage, I'm not following why it would make sense that language, wages and benefits, shouldn't just be referring to overall compensation the way everyone, I think, traditionally views it.
Yeah, well, I mean, there are a number of areas that arguably could be considered benefits that the state has already kind of taken over the area. And just to name a few, that would be unemployment compensation, workers' compensation, regulation of insurance companies. These are significant areas that the state has an established area of statute and laws.
But there isn't a voter initiative that says the state can't take over those areas of compensation. Unemployment happens outside. Workers' comp is a statewide, it's mandated above a city and county. And then you're talking about insurance. Insurance is regulation of an industry. So I think this is different. Do you believe it to be different?
We believe that benefits should not be interpreted as broadly as plaintiffs are proposing under any definition.
So when you talk about benefits being benefits constrained to this section of statute, adopted by initiative, and you say that benefits here are simply the protections accorded to the populace of enforcement mechanism kinds of things, and that's it.
One clarification.
Okay.
Our position is benefits means the advantages or privileges given in Article 8.
And is the only privilege given in Article 8 the amount of wages can't go under this amount?
That is one. Another is the penalties. There's a number of enforcement. So this law requires payment of only two things, a minimum wage and these penalties, whether it be for retaliation, failing to post notice, or otherwise violating the act. Those are the only two things that, when this was passed, it required payment of. Now, with the passage of Prop 206, there is another thing that employers are required to pay, and that is earned paid sick leave. The state's interpretation is that the benefits that cities are able to regulate would include the earned paid sick leave. That is a benefit provided in the context. So it's not, our definition is not just limited to enforcement protections. It depends upon the context, and it could include a fringe benefit such as earned paid sick leave, as long as it's included within the statute. So our definition is a contextually based definition of benefits. It's the benefits that the context provides.
Don't you think it's a rather strange argument to be making that when the voters voted for benefits, they were really voting for protections? I mean, it seems to me that the general rule would be that you would take the literal language of where they thought wages and benefits. We all know what that means, not wages and protections.
Well, 2 points, Your Honor. First, the Act, Prop 202, uses the word benefits and protections interchangeably. So that's one thing. The other thing is the assumption that voters were voting or understood that they were voting on benefits when Prop 202 was presented to them. There was no mention of benefits anywhere.
But again, we go back to the plain meaning of the statute, wages and benefits. Wages and benefits. It's used throughout statute to talk about wages, monetary compensation, benefits, non-monetary compensation that has some monetary value, like your paid sick leave, like your health insurance, like these things that are fringe benefits that come with work. So why should we set that definition on its ear for this statute only?
Two things. First of all, again, the language is not just wages and benefits, it's minimum wages and benefits. And I don't know that that phrase has a universal understood meaning, and that is actually borne out by a couple examples I'd like to point you to. First is ARS 2377-101. That uses the word wages and benefits together. And plaintiff had cited this statute before, saying wages and benefits are used here, it must mean fringe benefits. Well, if you actually look at the context of that law, benefits is expressly defined to only mean unemployment compensation. So just because the word wages and benefits are used together, it doesn't always mean that it means a general fringe benefits.
Back it up to expressly defined. It's not expressly defined here.
And I think
that seems to be the difference.
Sure, but that lack of definition, that the breadth that could do, I think that is a factor that weighs against plaintiff's interpretation when you consider the context here. Also consider Prop 206. When that law was passed, Article 8 was titled minimum wage. It was only through the passage of Prop 206 that it was changed from minimum wage to minimum wage and employee benefits, suggesting, again, just because benefits were there, it was not a subject that was encompassed by this enactment.
But are you suggesting that voters would not have read the language in the enforcement provision? I mean, if anyone just reads that, is there anyone who would come to a different conclusion that you haven't looked at the title of the referendum, you're just reading that provision? Is there anyone who would read that and say something other than, cities and counties, other municipalities are allowed to raise the minimum wage and they're allowed to require additional benefits?
I believe so. I think it's reasonable to assume, again, the word benefits are being used interchangeably with protections. You have a provision allowing payment of higher benefits when there was no benefits here required at all. Again, you have the context, and then you have other statutory presumptions that help guide the courts.
Context doesn't matter when it's perfectly okay to just couch it as a wage when it's in effect a benefit. If it's a retirement benefit you're providing, aren't you just providing basically a higher wage so somebody doesn't have to save their own money for retirement? It's compensation.
It's again, one thing that was a driving force behind ERISA, and I believe it was a driving force behind HB 2579, which is dealing with patchwork regulations. It is pretty simple for an employer to say, when the paycheck's cut, you get $40 an hour, assuming. It is much more difficult getting employee benefit plans in place, doing certain coverages. So if a city or the state wants to pass a wage law, the people know what they're understanding, and it's easier for employers to comply with. So I think that there is a regulation, and Arizona law distinguishes between wage compensation and non-wage compensation. So
Can we get to your fourth argument, because we're
Sure.
running out of time here? You talked about federal law conflicts with the reading of benefits to mean non-wage benefits as opposed to protections. Can you address that issue?
Sure. So, ERISA, I know, is not a fun area for me personally. I don't. It's a complicated area of law, but just in a nutshell, ERISA, the preemption provision in ERISA is very broad. The Arizona Law Handbook summarizes this, where it governs virtually all benefits, but there are a few exceptions. Earned paid sick leave is one. That's how come Prop 206 survives. But the point is let's just assume that fringe benefits means that benefits means fringe benefits in this context. The point is, it's undisputable. I don't think that this law would be purporting to allow cities to regulate what federal law doesn't allow them to regulate. Now, you can say, well, they know what their responsibility is. They're not going to do what they're not supposed to do. But the point is, I don't think you should, it's reasonable to interpret a statute in a way to authorize someone to do something when it's clear that they are prohibited from doing that thing.
Specifically, do you believe ERISA prohibits the state and local, well, let's go with municipalities, that group of individuals, that wouldn't be precluded if it was done on a state level? We're talking about a federal regulation, and you're talking about how we can't touch it. So how can the state of Arizona touch it?
The
If cities and
ERISA applies
municipalities-
equally to the state and local governments.
Precisely. So I'm not, do you understand my question?
Well, the bottom line is, why would we assume that they aren't going to follow your ERISA?
I'm not saying that they're not, but
So the statute, to the extent it authorizes them to make non-wage benefits part of their compensation packages, they have to comply with all the law, including the federal law. So
sure. But the point is that is their own personal restraint. Read on its face, this law would give them authority to do what ERISA doesn't allow them to do, and it's.
Wouldn't the other law give the state the authority to do what ERISA implicitly denies them the ability to do? That's my point. How is this different if you look at a locality versus the state when you're looking at a federal regulation scheme of fringe benefits?
Again,
Everyone has to comply with ERISA.
Correct. HB 2579 does not give the state authority to do anything. The state does not depend on.
It doesn't say the state can provide benefits greater
Correct.
than the minimum.
So-
You're just saying it has to be consistent statewide.
Sure. And, with my time short, I just would like to pose just one question. If benefits really means fringe benefits, that interpretation in and of itself creates ambiguity. We throw out the word fringe benefits as
Where do you come up with fringe as opposed to just benefits? If you interview for a job and say, what are the benefits? Benefits are the health insurance.
sure.
the
Let's just say,
medical,
okay,
dental,
let's just call it
retirement.
benefits. The point is even assuming that it means some kind of employee benefits, that in and of itself is ambiguous. It is not at all clear what that means. I mean,
It doesn't just mean compensation. Your overall compensation package. As a state employee, don't you get something from the state that says, here's your overall compensation package, which includes your wages and your benefits. And it'll give you a number down at the bottom that says this is your overall compensation package.
I believe if the court was to adopt that type of interpretation, that would be a sensible way of doing it. But that's not the way that plaintiff's counsel in this case and in other has interpreted the words benefits. They've gone so far as to, in another federal lawsuit, is to say that collective bargaining is a benefit. So again, what is significant here is the VPA, and that is, it prevents state regulation in this area. So it's important that this word be appropriately defined by context. And that is going to mitigate against future battles that come down the road. I appreciate the court's time. Thank you.
Thank you.
Good morning. May it please the court. My name is Jim Barton of Torres Law Group, and I'm here on behalf of the plaintiffs' appellees, and I'm joined with my associate, Kieran Goff. So I think that there was good discussion about the conflict between HB 2579 as enacted into ARS 23204 and how that conflicts with Proposition 202's enactment of ARS 23364. I think I'd like to add to that discussion somewhat to note that it's important to realize that 23-364, which is what comes out of Proposition 202, was by its terms expansive. It authorized the legislature to go beyond what the proposition proponents did. It also acknowledges that it said explicitly that it didn't want to restrict any body from adopting a law or policy that requires the payment of higher or supplemental wages or benefits. So you can see right away that there is an envisioning that this law could do more. So, for example, had the legislature enacted sick leave rather than the citizens, it took the citizens to do it, but had the legislature done that and added it to the article, then that would have very clearly been a floor benefit that Proposition 202 would say, well, cities, you can go above that floor benefit, you can give more days or you can do whatever, but once it's in the article, you can't go below the floor. I also want to make sure we think about the history of how these various statutes came to be. In 2006, the voters passed Proposition 202, which enacted the 23-364 that we're here talking about. In 2013 is when the legislature enacted 23-204, so that's the sort of competing section of the statute. And when that was enacted back in 2013...
Does it necessarily compete? I'm sorry to kind of derail a little bit. The initial bill, the referendum, sets a floor, and you can't go under that. The new law doesn't try to go under, doesn't tell anybody that they can go under these required minimums. It just says we want consistency statewide in how we go over those minimums. Why is that a conflict if the purpose of the law is to set a floor and say nobody can go under that? It's not requiring cities or municipalities to go over it. Admittedly, I'm reading it as saying cities can do that, but there's certainly no requirement that cities impose something greater. And this is just, there's still no requirement with the states, with the new law. There's no requirement that anybody go higher. It's just saying, but if you do it, we want to have some consistency statewide. Why is that necessarily a conflict?
It's necessarily a conflict because the Proposition 202 not only set the floor in one particular area of the wage, it also authorized the cities and municipalities to go above that if they wanted to, if they found it was in the interest of their citizens to go above that. So the reason why, as initially passed 23-204, conflicted with Proposition 202 is, of course, because it was initially passed, it said the regulation of employee benefits, including compensation, paid and unpaid sick leave, then it lists some others, is a matter of statewide control, and it can only be controlled by the legislature. So, yes, the Proposition 202 did set a value that was a floor, and it gave a little, annual increasing with the COLA. But then it said also, by the way, we're empowering the municipalities to do something better if they want. And by the way, it also explicitly said the legislature can do something better and more if the legislature wants. So I think the next step in the story is in 2015, there was a group in Flagstaff who they weren't doing 20 or 40, but they wanted to make a higher minimum wage. And they sued the state and said, this law as it's written is unfair. It conflicts with 202. The Attorney General's office on behalf of the state settled that lawsuit and agreed, yes, previous 204 conflicted with Proposition 202. We can't interfere with minimum wages. That has been granted to the municipalities. Then we amended it in 2016. That's 2579. That's where we are today. And you just basically drop non-wage in front of the compensation component of it. So now it reads the regulation of employee benefits, including non-wage compensation. So, we talked some in the briefing about implied repeal. And this is technically implied repeal in as much as it doesn't write, 23-364 and line it out. But that's the only way it's an implied repeal. I mean, this to me is very directly a response to say we couldn't take away wage regulation. We accept that, but now we're trying to take away the regulation of benefits. And I think it just plainly contradicts with the language of the statute. On the ERISA question, I do want to note that what 2579 is doing is it's saying the cities can't regulate these things, but it leaves the states to regulate it. So I think there was some questioning about that as well. The cities maybe could violate ERISA if they did something bad, and if that happened, I'm sure there would be people to sue. The state might violate ERISA, and then someone would be present to sue, but there's no extra ERISA protection by taking away that authority from the cities and giving it back to the state. I do want to talk about the fees issue as well, but I wanted to pause there and see if there's any question as far as the substance goes and the interplay between Proposition 202 and HB 2579. The state does challenge the lower court's decision to grant attorney's fees for the entire amount of work done on this case. And it focuses on the fact that there were plaintiffs who were dismissed from the case, and there was an unsuccessful argument based on the home rule provision. The parties came to this to have HB 2579 declared unconstitutional, and they were successful in that. And I think that's an important starting point, is that all anybody wanted to do who was in this case was to have HB 2579 declared unenforceable, and they succeeded in that. Also, it's one set of attorneys who argued both. It's not a situation where you have attorneys piling on. It was one set of counsel that brought forward two theories on that. And so we have this very interesting question about, well, should the counsel be paid for, should the parties be reimbursed for the money they paid their attorneys for the theories or claims or causes of actions that were unsuccessful? And the governing federal law here is the U.S. Supreme Court in Hensley v. Eckhart. And in that case, you'll notice that what the court really emphasized was how successful were the litigants. And the court envisions that, there would be times when, the litigants would recover for an unsuccessful argument, or perhaps they would be paid for time that went to a contention that was raised in the lawsuit wasn't successful, so long as at the end of the day, the parties were successful. By contrast, if the parties were only partially successful, if there was some claim that won and some claims that lost, some result that they wanted that they got and some result they wanted they didn't get, in that case it makes sense to reduce the attorney's fees. And so I think...
Well, let me ask you this.
Yes, sir.
Okay, so you have multiple plaintiffs that have filed a complaint. And in that complaint, they've raised what I'll refer to as two issues. The one issue that we're here on today, and the home rule issue, correct?
Yes, Your Honor.
Okay. So there's a motion to dismiss, and it's a motion to dismiss all of the claimants except the legislators, correct?
Yes, Your Honor.
Okay. That motion was granted.
Yes.
Why should the government pay for those fees?
They should pay for those fees because the legal work expended on behalf of those clients and on behalf of that argument was part of a successful effort to have
Okay? But you
overturned.
only needed one legitimate plaintiff to carry forward. So once there's one and they didn't even dispute it, they just moved to dismiss, you could have said, okay, we have one plaintiff, so let's go.
Yes, Your Honor. If we'd had one plaintiff and said, let's go, we would have had the same result that we had here today. There wouldn't have been less legal time. Everything would have been the
Right,
same.
a lot less legal time, lot
No,
less
I don't
legal
think there would have
fees.
been.
Sure.
I don't know if there would have been less legal time. Are you
That was
saying?
my question. Your motion to dismiss was based on trying and argued and litigated was trying to keep other plaintiffs in the lawsuit.
Well, it was trying to keep other plaintiffs in the lawsuit, but it was primarily trying to move forward a legal argument that the home rule provision would ban this.
Okay, so is there any way to distinguish between those? I mean, in your China Doll affidavit, did it directly apportion time and effort spent for those different areas?
I don't believe that we didn't specifically break it out. I think you can certainly look at the affidavit and tell which hours go to which argument. But I think that, so I think it is a knowable quantity. I think it can be seen. But I think that, and I'm looking now at the Arizona Center for Law and the Public Interest v. Hassel case. In that case, like our case, they put forward two reasons to have a law declared unconstitutional. One, they said it was special legislation. The other, they said it was the gift clause. They lost on the special legislation, but they prevailed on the gift clause. And in that case, because the result that they sought was exactly the result they sought from the beginning, there was no reduction in fees to offset the money spent on this unsuccessful claim.
I thought in that case it was difficult to apportion the different arguments. I mean, you're standing there arguing a summary judgment motion or something like that. How can you say, well, I spent 20 minutes arguing this and 40 minutes arguing this? I mean, we don't bill like that. So, but in your case, I mean, you expended time and effort to keep plaintiffs in an action when you didn't have to. Because the government admitted that you had one plaintiff that was a viable plaintiff.
Well, yes, Your Honor, but that one plaintiff couldn't have brought forward the home rule argument. So I understand.
Which you didn't prevail on.
That's right. So, but I think, in other words, we needed to keep the home rule argument. I think it would have been reckless for us to let the home rule argument go because that was, in our opinion, a legitimate other reason why this law was unconstitutional. So I think the time spent is, although it is involved different plaintiffs, I think the time spent involved a separate argument that was a part of the prongs, if you will, that we used that we ultimately prevailed on. And so, for example, one of the things in the case that we saw in the Dobson case, which was where the court was sort of considering, the Supreme Court was considering the matter as a direct, it was an original jurisdiction with the Supreme Court, so they apply discretion themselves. It's not like here the trial court has had an opportunity to pass on this question, and the trial court determined that all the fees were reasonable. So that we didn't have the benefit of that in Dobson. But in Dobson, the court looked at claims that were dismissed before it came up to the Supreme Court, so it had been filed but dismissed, and so they didn't have an opportunity to, for example, examine if the claims were intertwined. So, for example, in this case, in our case, we said the home rule provision applies because the localities are granted this authority that we've been talking about. So that means the home rule provision provides because the citizens have explicitly said this is a matter of statewide concern. Now, we failed to keep the parties in that could raise that complaint, so they were dismissed, and so we didn't have standing to continue on that claim. But the time spent on that claim, what I'm saying, is intertwined with the VPA claim because of the nature of the claim itself. And also,
didn't the court in Dobson say that you were only entitled to, or that the party there was only entitled to fees on the winning issue?
It did, Your Honor. And in Dobson, that was a matter there's original jurisdiction, so the Supreme Court didn't have the benefit of a trial court's evaluation, or if you want to say it another way, it was sitting just as a trial court, and it made an initial determination that in that case, only the winning issues should be compensated. What I'm saying in this case, the trial court, who had the benefit of looking at the whole record, determined that reasonable attorney's fees included the successful and the unsuccessful arguments, which is akin to what happened with center-in-law in the public interest v. Hassel. Again, there they had a successful argument and unsuccessful argument, and they were compensated. They were compensated for both. I would also contrast this with one of the cases that we have in the briefing, which is the Bishop v. Peacock case, which is a personal injury case where one of the parties wasn't successful and received no recovery. In other words, that party didn't get what that party wanted, and so the court held it was wrong for them to recover fees for that party. So, for example, in this case, if the union was going for something else, like the union wanted to have another part of a law thrown out, or a union was suing for another law, then I would agree the time spent representing that home rule case, or the time spent representing the union's interest in the VPA case, I would agree that you could separate those out. But in this case, everything was pushing for the same goal, which is to hold the law unconstitutional. Everything was successful in that, and so that's why I think we're now in the realm of the Center for Law and the Public Interest v. Hassel, where even though one claim was unsuccessful, we were ultimately successful in what everyone wanted to do from the beginning, and so we should be compensated, or they should be compensated.
But Judge Rogers didn't make any delineation between the fees. He just simply said, granted, and awarded the entire amount. He didn't go through and make a determination that these fees were all, as you say, interrelated or whatever. He just gave us a blanket, pay them all.
Well, Your Honor, that's true, although he had the arguments from the parties that were before him on the fee application. So, I mean, he was presented with an argument that we shouldn't recover any or we should only recover part, and he made his decision having seen that argument and having had the benefit of seeing the litigation. That's all I have, unless there are other questions.
Thank you, counsel. All right. We thank you both for your arguments. We will take this matter under advisement and issue a written ruling in due course. Have a happy Thanksgiving. We are at recess.